Hi, my name is Kruse. I'm an attorney and the owner of Kruse Family Law, located in Minneapolis. Welcome to our new video series, The Basics of Minnesota Divorce. The purpose is to provide a quick overview of some common divorce issues. This is not intended as legal advice. Okay? All cases are different. Please consult your own attorney before you take any action in your own divorce. Today, we're going to talk about who may bring a divorce action in Minnesota, because not just anyone can do that. You have to meet some jurisdictional requirements. The most important of these is that one of the parties has resided in Minnesota for at least 180 days. If you move here, if your spouse moves here, if both of you move here, doesn't matter, at least one of you has to be here for about 6 months before you can start a divorce. Now, if you are in the military and you're stationed elsewhere, you could still bring a divorce action in Minnesota if you've kept your Minnesota residency. So, for example, maybe you're in the Navy and you live in Norfolk, Virginia, but you kept your Minnesota driver's license, you still pay taxes in Minnesota, those sort of things. Presumably that would be enough that you've kept your Minnesota residency and you can bring the divorce action in Minnesota. Do keep in mind that there is something called the Service Members Civil Relief Act that protects service members who are deployed. If, for example, your spouse is deployed in Afghanistan, you are going to need to wait until they get back from that deployment to file or serve your divorce action. In addition, one of the parties needs to live in the county in which the action is brought. It doesn't need to be both of you, only needs to be one of you. Now, if you both live in the same county, for example, Hennepin, then you would file in Hennepin County. But let's say one of you lives in Hennepin and one of you lives in Crow Wing. Well, you could file either in Hennepin or in Crow Wing. Doesn't matter, at least as far as the courts are concerned. Now, presumably you would bring it in the county where you live because that's going to be much more convenient, but you don't have to. So how is a divorce started? Well, Minnesota differs from most states, and the state courts in Minnesota differ from the federal courts. In Minnesota State Court, which is where all divorce actions are brought, you start a process, the divorce process, or any legal process, by serving the other party rather than by filing with the court. So what you need to do to start a divorce action is to serve your spouse with a summons and petition for dissolution of marriage. That service can be made by anyone who is age 18 or over and is not a party to the action. So you can't serve your spouse, but a friend of yours could serve, or maybe you want to hire a company like Metro Legal to serve, or if you have an attorney, he or she is going to handle that service for you. Once service has been made, the person who made the service needs to complete an affidavit of service. This is a document signed under oath attesting to the fact that you served the other party with the papers. You don't need to file immediately, and this can be advantageous in divorce actions, and often we don't file immediately. You serve the other party, and then you take time to try to negotiate before you get the court involved. But once you do file, the court is involved and the court is going to set the schedule. I hope you found this very brief overview interesting and helpful. If you have a family law question, visit our website at krusefamilylaw.com. There are links to a number of resources that may be useful to you. You can also call us at 612-231-9865 or email me, Corwin at krusefamilylaw.com. Thanks for watching. Have a good day.